I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review. But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance. It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just that it's the defense strategic choice. And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Cochadimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And, to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the root anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's a waste of time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process. Under the Utah State Constitution and the federal Constitution, she is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it
Which
all go back.
specific part? You got to be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. Stay away from going back. Let's just stay on publishing. So I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings and then allow counsel to make whatever arguments they want to make about you should go back and listen to this part because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
Our
you're
objection
saying publish.
stands.
Let me start again. Imagine that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that. Then it should all go back. Or
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
Showing up on the screen.
so my hesitation is just efficiency. Like I said, it's over 7 hours worth of video. But if that's how the court wants to do it, then yes.
No. That's what I'm asking you. So imagine, here, I'll just make a ruling. I have considered carefully the authorities cited by defendant and the state. I've looked at the text of Rule 801. Ruling is a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath, was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So, Ms. Lewis, take it from there. Some of her prior consistent statements as designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I
We
guess-
could just
Sorry.
publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth, out of an abundance of caution, is saying prophylactically, to prevent any appellate issue there, we would just publish. But if the defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them, you could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R. I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back, or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview is, I don't think it's productive. I think it's a waste of the jury's time.
Okay. Ms. Lewis.
We object to it all going back. It's the same problem. The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
Because there are, I mean, I already made my issue or raised the issue about the May 10th.
We'll get
Transcript.
there specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part. But there's a lot that's being left out, and a lot what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
You haven't, but that's okay. You can certainly have access to this witness.
Well, I think we've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I don't know the answer to that fully yet, but there are a lot of other statements by both detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because, I mean, all of them.
Okay. All right. That is hard to rule on because it can't be all.
Why not?
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know, and now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would, I mean, we want all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that, but.
The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does. And that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Ms. Lewis.
Yes, Your Honor. We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago, and I raised it with you yesterday morning.
Okay.
Your request for a 2-day continuance is denied.
Ask for a 1 day. Ask for 1 day.
All right, a 1-day continuance then?
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah?
Mr. Bloodworth.
Your Honor, the state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yes?
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes?
That is so slow. There's just no way this is going to work. There's no way we can edit the video?
I'm not tracking, Your Honor.
Each of these transcripts corresponds to a video of an interview, correct?
Correct.
It would seem that watching and listening to the video is more efficient than reading the transcript.
Oh, 100%, Your Honor. Based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it.
Okay.
Let's just cut to that chase.
All right. Folks, give me 5 minutes. Actually, just give me till 11. We're back on the record in 231-500-139. Counsel for the state and for defendant are present. Defendant is present. Ms. Lewis, the defendant, asked for a 1-day continuance to allow time for defendant to, on the one hand, review the designations made by the state, determine whether there are some over designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive, and if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video, so that when we're publishing a video not just pages of a transcript. Let's work backwards from there. How long is that process? And if you need to take a moment, step out and tell your video editor to press pause, I'd understand.
So, the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out,
Right.
hard to say. 4 hours?
Okay. All right. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to come
So-
back midday tomorrow.
So we can do that, assuming was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis?
We're just discussing, I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in 12-point font.
But the
The
whole-
Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designating, you're just taking stuff out of those. So it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I'm sorry, I don't understand. What you
Well,
mean.
if, for example, there's 200 pages of interview with Jeff O'Driscoll the first time, and the state's just trying to put in 20 from the beginning, you don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not. They're just portions that are prior consistent statements. And so it's, did they over-designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify, provide context, or explain?
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on recent motive to fabricate.
Yeah, that is the same. That's that's the prior consistent statement rule.
I think there were 2 separate things in 802D1, but maybe we're saying the same thing.
801D1B.
I mean 801D1, yeah.
is consistent with the declarant's testimony and is offered to rebut. So
Right.
it's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon a lack of memory.
Nothing in A.
Right. I think we see it the same way.
Okay.
We have till 11 p.m.
No. I need time to read it. The state needs time to read it. This is possible. I want to make sure that we have a common understanding of what you'd be permitted to do under 801D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over-designation by the state under the bounds of 801D1B, I need to know. And if, in defendant's view, there's a Rule 106 inclusion that's required before or after these designations, I need to know.
Understood.
Okay, so 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, what I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
Okay. Now, in terms of how to proceed for the remainder of today, do you want to put Kotridemus on and get him done, or do you want to break now?
Your Honor, if we can call him, he's 10 minutes.
Okay. Any objection, Ms. Lewis?
Eating into time.
All right.
Oh, okay.
Well, he's only going to be 10 minutes.
Yeah.
All right.
All but taken out.
Okay. Got it. And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that sound reasonable?
Yes, sir.
Okay. Very good. Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.